What's your name?
Brandy Kilgore.
And what's your name? Pardon?
Bailey Susan.
How we doing?
Sir, how are you?
Counsel, your appearance?
John Capitan, appearing on behalf of Granite Televalley.
I see. I can't even read my own writing, but you must have been on Zoom and you couldn't get on Zoom. I adjourned it a week. Did you two listen to and understand the rights? Okay, let's start with you. Ms. Sanchez, you listened to and understood the rights? Do you wish to speak to a lawyer? Do you intend to apply for funding?
Sure.
Ms. Kilgore, did you listen to and understand the rights?
Yeah.
Do you wish to speak to a lawyer? And you're saying you've applied for funding, Ms. Sanchez? With who?
DHS.
When did you guys submit that application?
Submitted this morning.
Did you bring it to the court?
Verification on my phone. They didn't.
You're gonna go down the hall and show probation. We're gonna adjourn this to February 20, not probation, to the civil department. February 23rd at what time, Linda?
9 o'clock is good.
At 9 o'clock, okay? Go down, you have to provide them with proof of that right now.
Oh.
You come back. Mr. Capitan, what is the total amount owed?
Oh,
I don't need to hear a breakdown now.
All right. The total amount owed is $4,318.92.
So ladies, you better get moving on that.
What happens when unpaid rent turns into a money order mystery? A defendant shows up allegedly drunk to court on felony charges, and a foreclosure buyer tries to fast-track someone out over missing stairs. Today's docket is absolute chaos. We got disputed payments, bounced Western Union money orders, a judge doing alcohol math in real time, and a heated foreclosure battle over a redemption period that could cost someone their entire property. And just when you think it settles down, boom, an eviction deal gets struck under pressure. Stay locked in, because every single one of these moments has legal consequences that could change lives instantly.
So they're not going to give you that kind of money, I don't think.
No, sir. We are actually disputing $1,027 of that. Taylor Valley received $1,027 in money orders from us on the 27th of November. And they called us, I believe it was about the 20th of January, saying that the money orders went non-sufficient funds. So I contacted.
Do you know anything about that, Mr. Capitan?
Your Honor, I do not know anything about that at this time.
Who's this?
However,
You're from Granite?
Yeah.
Come on up here. Your name, ma'am?
Suzanne Bryan, Granite Televalley. I brought all the correspondence on those NSF money orders.
How do you get a money order? I thought you had to pay for a money order.
You do, and I
How can that-
requested them to find out who signed them. It says that they were cashed out. to-
Where are you in possession of, well, but wait a minute.
It's gone through 2 banks, and they both came back against that.
Where'd you get those at?
I got them at Myers, they're Western Union.
Okay, hang on.
Contacted Western.
Hang on. Don't slow down. Go back to Meyer.
Oh, we did. They could not help us there at the Myers.
You're gonna have to figure this out. I don't believe this lady would be in here telling me that they were NSF checks if they weren't NSF checks. If she did that, she knows she would have absolutely no credibility with me until I leave this bench. You understand what I'm saying?
Yes.
So you're gonna have to go over and figure it out. Something happened.
We've already been doing that. We received copies of the checks from Western Union, and those checks stated that they cleared their account on the 19th of December.
Yes.
They were NSF again on January 23rd. I have all.
Sit down, you two, before you leave, you three, and go through the paper. Something's wrong. So you guys check it out. You come back for a court date, February 23rd at 9. And I just want you to know, it's going to be your responsibility to make sure those funds were cleared. and you got 4318 less 1,027. So you got somewhere in the neighborhood of 4191, and I think it's 82 cents. So that's what they think you owe if you paid that, right?
Yes.
All right, so that's what I'll do. I'm adjourning that. You guys figure it out. But I don't think she'd be in here telling me they bounced if they didn't bounce. That's all.
And where do we go to submit the proof for assistance? You told us to go submit proof for assistance that we applied for?
Oh, I'm sorry. Sorry about that. You're gonna go down to the civil department. All right, thanks. Which one's Mr. Bodges? You're all set, ladies.
Here.
Which one does he have again? Who drove here?
She did.
Does he have a bond, Heather? I want you to call Heather.
Yeah, I think.
Okay, you want her to pop on again?
I do.
Okay,
Okay, ladies, you can go out in the hallway
Yes,
and talk,
that's outside.
okay? I don't know what you're doing, Mr. Bodges.
January, I'm getting beat down good. I would have.
You don't go yelling like you did at me last week on here. You got me. No. You don't do that. I don't care if you've had 49 vodka tonics or whatever else. You don't do that. Now you show up drinking again,
It was yesterday.
Mr. Bodges.
Yes, sir.
Alcohol basically dissipates at the rate of 0.125 per hour. That means if you stopped drinking at 11:30, you were somewhere in the neighborhood of about a 2.0. I can do the math easily if you're interested in an exact reading. So if you're telling me you haven't drank since yesterday, then you were highly intoxicated before you went to bed. And that's your prerogative. If you don't have a bond condition that says you can't drink. Heather, I would like you to check and see the felony that Mr. Bodges has, whether or not he has a no alcohol provision in there.
What is the first name, Judge, on him?
Ronald, R-O-N-A-L-D. We burned it over. I don't remember. It's a felony. I don't remember if I
Okay,
did.
okay, that's why I'm looking at. Okay, so it's a bound over case.
Right.
With Judge Hessen?
When did this get bound over? Just
Did your
recently?
case get bound over from district court, Mr. Bodges? When were you in district court on the felony charge, sir?
Was it?
I didn't ask you that. I didn't ask you.
I'm sure. So maybe.
October, he thinks.
No, Your Honor, I think it's November
Oh,
3rd.
I do see one in here that was bound over on November 18th.
Was that mine or Judge Hessen's?
This one was yours.
Is there a no alcohol provision in that?
Let me take a look on this one. Yes.
That's what I thought. John, I'm not gonna swear you to an oath. You took a PBT reading this morning on Mr. Bodges, right?
Yes, Your Honor.
State your name.
It's John City.
I didn't mean to stump you.
Yeah, that's how to think about it for a minute.
Point 0.088 he had, right?
Yes, Your Honor.
Okay, so I think probation needs to notify, or somebody needs to notify the courthouse, whatever judge is assigned, that Mr. Bodges showed up here. And this is the second day. He smelled of alcohol last time. I didn't have him tested last time, which I guess was last Tuesday or on the 27th. So, I don't think you can handle this case while you're drunk, Mr. Bodges.
I'm looking for a concern right now. I got a call two of them last week. Four of them last week. I'm too poor for legal aid and maybe too much for paid legal aid. So I called a couple personal lawyers. And I just got paid at first.
You're to come here without drinking next week. That was what I told you to do when I set the bond on that case. Now you got a now according to her, and I'm not going to get into this, you got a felony. What's the charge again?
That charge was Let me make sure. Hold on. There was three counts. The first count was assault with intent to do great bodily harm, less than murder. Count two, assault with dangerous weapon. And count three, assault with dangerous weapon, felonies, assault.
So you got a 10-year felony and 2 4-year felonies pending.
Yes, sir.
And you're,
Gonna beat that.
and you're violating a judge's bond conditions. Now, if I had jurisdiction, I'd lock you up right now. Once I sign that bind over certificate, I don't have jurisdiction, which is why we're going to notify the court. Counsel, I'm adjourning this 1 week. If you come here, I'm giving you a PBT again. You understand?
Yes, sir.
And next time, I'm not going to adjourn it. There's going to be consequences for you showing up here like that. I'm going to adjourn it 1 week to February. What do I have? The 9th, is it?
Yes, February 9th at 9:30, Your Honor.
At 9:30.
Let's pause right here because this is where things get legally interesting. The court is dealing with a $4,318.92 balance, but the defendants are disputing $1,027 based on money orders they claim were properly purchased and cleared. Here's the issue. Money orders typically don't bounce like personal checks unless there's fraud, processing error, or misrouting between financial institutions. The judge makes a credibility call here. He openly states he doesn't believe the property representative would risk her courtroom credibility by falsely claiming NSF funds. That's huge. In small claims and landlord-tenant matters, credibility is everything. If those money orders truly cleared Western Union, the defendants need hard documentation. Not screenshots, not assumptions, bank confirmation. Question for you. If you had receipts showing payment cleared, would you trust the system to fix it, or would you be nervous walking back into court?
In the morning. Ma'am, did you drive here? You're not going to let him drive, right? Because that would be a crime. Okay? That's all I can do, Mr. Capitan.
Thank you.
You need to straighten out your life. Good luck. Thank you. What is this? Your name, sir?
Yes, it's which road, Austin,
All right, counsel. What is your allegation here?
Our allegation is that the property has some damage to it that threatens my client's investment after an inspection from foreclosure by advertisement.
What happened? They bought it at a mortgage foreclosure, right?
Yes, my client did that. We inspected the property. We found some
Redemption period expired, right?
Not yet, Your Honor. We inspected the property and we lost track of Mr. Dawson and communicating with him about some issues we found with the inspection. And so we filed this action. Really just like to talk to him again to make sure that everything is still okay with the property.
When did the mortgage sale, the foreclosure sale take place?
October 16th, Your Honor.
So you guys wanted termination on the basis that there's language in there that says that the property has to be kept in a reasonably habitable manner, and you want an immediate writ. Is that right?
Not exactly at this point, Your Honor. I think my client just wants to be able to re-inspect the property after the initial inspection and ensure that the issues that we found at that initial inspection have been taken care of.
Come here. Let me talk to you a second. I hate these, by the way.
I know you do, Your Honor.
Well, I think any judge worth 5 cents hates these. I mean, you're saying bring your exterior ingress / steps to code at back door.
Yes, Your Honor.
Is that the main complaint?
That is the main complaint, Your Honor.
That's ridiculous. I want to know if there's a judge around, and don't tell me now on this YouTube here. Don't tell me now if there's, I don't, that is ridiculous. That was not the intent of this statutory language. And I'm unless you can tell me something else, what's wrong with the code? What's wrong with the steps? Can you tell me?
No, yeah,
I'm dismissing your case unless you can tell me something real quick, Mr. Devlin. I hate these. And I'm not the only judge that would hate these. It's ridiculous. they get the property and they can't wait to get their hands on it. These people still have the right to redeem the property. What do you have to say? Anything else? Otherwise, I'm dismissing this.
Your Honor, the stairs don't exist.
What's that?
The stairs don't exist. It's not, there are no back stairs and there is,
I'm dismissing your action. You guys can take an appeal.
understood, Your Honor. Do you need?
Do you have any stairs in the back?
No stairs on the compound.
How long is, when you bought it, were there stairs on the compound?
No stairs on the compound. Bought this
When did you buy it?
2023 of 12/26. 12/26/2023.
Are you gonna be able to redeem this property?
This is why I am here today, Your Honor, because I wanted to alert you that I have had no right or statutory right for redemption. And so
Wait a minute.
Yes.
Wait a minute. I don't have anything to do with the sales that happened.
No,
No,
the deed.
I want you to listen to me. son.
Okay,
Okay? I don't have anything to do. All they come to the district court for is to ask us for possession of the property when the redemption period is passed. In this case, they're coming to us and asking us for redemption, early writ being issued, I should say, and executed upon, in this case, because of the violation of the code that you don't have any stairs. That's what they're doing. You're gonna have to talk to a lawyer about how to redeem it. You're gonna have to figure out what the redemption amount is, and you only got so many days. I don't know when he said, but you gotta get to a lawyer real quick. Who's this with you?
oh, that's my fiance.
Well, you're okay, ma'am. You can sit there, but do you understand what I'm telling you?
Yes, Your Honor.
Mr. Devlin, if I'm being too harsh, you can tell me, Judge, I think you're too harsh and I want you to be heard, and I'm gonna let you be heard. And it's okay, we can agree to disagree. I just get tired of mortgage companies salivating, or the buyers of these foreclosures salivating to get the property early. It's like they don't have any, they have no patience on it. They think they can write their own rules. These people moved out. I get all this nonsense. So tell me why I'm wrong in looking at it this way. And I'll trust you're going to be respectful. I'll be happy to listen.
Your Honor, I think that the primary concern in this was the lack of communication from the defendant to us after we found the issue with the property. If you're trying to make a judicial determination that the damages that we're alleging don't arise to the level required for termination of the redemption period, I respect that. That is a finding of fact that is your job in this case. However, we were trying to get back in touch with the defendant who became non-responsive to us.
You're going to work on getting that taken care of though, right? Listen.
Hey.
You gotta have, you should be working on getting that taken care of and working on getting the property back. What is the redemptive amount? Can you tell me, Mr. Devlin?
I can give you a general idea, Your Honor. I'm gonna guess that this was a condominium foreclosure, as the amount is under $10,000.
I'll figure out a way to get the money together.
Your Honor, I would calculate
Hang
the
on.
redemption period is April 16th.
Listen, figure out a way to get $10,000. I don't care if, listen, can you do that? You don't want to lose this property.
No, not at all. I haven't really had an opportunity to, because what I'm here for is,
Sir, they're asking for an early writ. They're asking me to accelerate the redemption time period and saying, give us the property back. He's let the property become uninhabitable, or, now, wait a minute, everybody wants to raise their hand out here. Just let me finish. Talk to a lawyer, talk to Mr. Devlin. He's saying you can redeem the property for somewhere less than $10,000. You have until April 16th, right, Mr. Devlin?
Your Honor, that's my guess based off this being a 6-month redemption, which is usually what a condominium is. I don't have the sheriff deed up in front of me. I'm on my phone right now. Tough for
Yeah.
me to flip around.
Double check. I don't think I do either. Maybe I
Yeah.
do.
You should have it, Your Honor. Here, I'll verify.
Yeah, it is October 16th.
October
Listen,
16th is the sale, so
listen.
yes, April 16th is the redemption. Your
Get the
Honor.
money together. Get the money together so you don't lose all the equity in the property, okay?
Yeah.
All right. I'm dismissing this action.
Your Honor, do you need me to submit an order?
Pardon?
Do you want me to submit an order?
Please,
Will
please.
do. Will do, Your Honor.
Thank you. Good luck.
Have a good
I'm
day.
helping you out. Go get the money to redeem the property, okay?
Get in contact with, Attorney Devlin.
Yeah, but get the money together. You might want to talk to your own lawyer. I don't know what your financial situation is. You can call Attorney Devlin and speak to him.
Absolutely, Your
Okay?
Honor.
Good luck. Thank you.
Thank you, Your Honor.
Thanks, Mr. Devlin. Golden Management versus Cindy Davy and all occupants 26001. Name?
Hi, Stephen Summers.
Your name, ma'am?
Mrs. Summers?
Ms. Tucker, I don't know why you sent all this over the weekend. I mean, I gotta have a chance to read this. I can't. Your name?
Wendy Tucker Beck.
I mean, how am I supposed to read all this? And
I apologize, Your Honor. I have counsel here with me today.
who's your lawyer?
I've retained the law offices of Aaron Cox, I believe.
Where's Mr. Cox
attorney,
at?
I believe Miss Attorney Saab is standing in for him today.
This moment right here shifts from civil frustration to serious criminal stakes. The judge breaks down alcohol dissipation rates, 0.0125 per hour, and calculates backward to show that if Mr. Bodie's still had a 0.088 reading, he was heavily intoxicated the night before. That's not just a lecture, that's a warning shot. Here's why this matters. He's facing a 10-year felony for assault with intent to do great bodily harm, plus 2 additional 4-year felonies. And on top of that, there's a no alcohol bond condition. Violating bond conditions while awaiting felony proceedings is extremely dangerous legally. The judge even says if he had jurisdiction, he'd lock him up immediately. That tells you how serious this is. Showing up intoxicated to court when your freedom is on the line, that's playing with fire. Be honest. If you were facing a decade behind bars, would you risk even one drink?
Honor, if you may just pass.
I'm sorry?
If you just may pass on this matter briefly while I conclude in another court.
Yeah, I'll do that.
Thank you, Your Honor.
Well, you guys can all stay put. You can have a seat. I'm done with Hidden Oaks. We have this Tucker one, and then I have the Butler one. And the property address is where? It's on Grange? I might just have to go over there before next week. Maybe I'll go over there. Ms. Tucker, you hang out until Mr. Soap gets ready. I'll pass your case. You folks can have a seat right at the table there, okay? Right at the table.
Thank you.
If your son is ready.
All right, let's go ahead. Wendy Tucker Beck versus Stephen and Lisa Summers, 2605336. Everybody's name again. Sir, your name.
Stephen Summers.
Ma'am, your name. Mr. Soap, do I have an appearance from you?
I'm on behalf of Aaron Cox, Your Honor. Yes, we did submit an appearance.
We have an appearance, Linda or Jennifer?
Yes, we do, Your
So,
Honor.
Counsel, I'm trying to go through this and I don't know what this is about, but let me tell you some things that trouble me. I just received all of this. They apparently Ms. Tucker Beck sent it in Friday and today. I don't know what I'm looking at here. It says, or was it Judge Hessen? There were both my friends. I don't know who I'm supposed to be friends with or Judge Hessen's supposed to be friends with.
Your Honor,
Hang on.
I
Thanks,
didn't-
Derek. Landlord tell Rockwood Police and Judge McNally that. See you soon. Where is this all coming from?
That's stuff that I,
Well,
and that was, some text messages, they didn't.
I don't like my name being mentioned, and I sure don't like people.
That was sent to us via text message from the landlord that works for her.
That works for Ms. Tucker Beck?
Correct.
Who's that? Who's your land? Who am I
I-
supposed to be friends with this time? I mean, I got so many friends that hold me out as their friends. If I had half as many friends as purportedly are my friends, I wouldn't be at a district judge. I'd be the president. What is this? Is this Mr.
You're-
Loringer?
Yes, sir.
Mr. Loringer, I don't know outside the building. He used to come in front of me quite a bit. Mr. Sobe, let's cut past this. I just don't, it just alarms me when I start hearing I'm friends with people that I don't even know. And I've heard enough of that lately. But listen, what are we going to do about this? I didn't have a chance to review any of the documents. You sent a slew of documents here. I don't know what I'm going to do with all of these. I mean, I'm certainly not reading them, speed reading them now.
If I may, Your Honor, this is a second hearing. I was made aware of a certain settlement offer that I'd like to present to the defendants. If I may do that, and I don't know if you want me to do that in a private breakout room or if I can do
Yeah,
that
I
at
shouldn't be privy to settlement discussions. I shouldn't be at all. So,
if they have a phone number, I would be more than happy to give them a call.
you guys want to give them the call? Give them the number? What is it?
586. Oh, I don't know.
Was it in the car?
It'd be 248
248
416
416
0737.
0737. Call them. I'm getting off the bench again. Yeah. We'll go from there. Okay.
Okay, I'll give them a call. Your Honor.
Thank you. You guys go outside or someplace quiet here and talk to the lawyer. Okay. And then you come back in.
yes, Your Honor.
Name.
Wendy Tucker Beck.
Your name.
Stephen Summers.
Your name.
Lisa Summers.
Did you guys resolve this, Mr. Sobe?
We have, Your Honor. I spoke to the defendants. Both of them have agreed to a consent to convert this into a termination of tenancy matter and to set the writ date as February 23rd, 2026.
And you're abandoning any money judgment?
Yeah, we are going to remove the money
You're
judgment.
simply agreeing to that they're going to vacate by the 23rd.
That's correct, Your Honor.
Mr. Summers, do you agree to that?
Yes, sir.
Ma'am, Ms. Summers, do you agree to that?
Yes.
So you understand that this is going to convert to a termination of tenancy. No matter what happens, you have to vacate by February 23rd. If you don't, they're going to present an application for a writ. If you're still there, a few days thereafter, you're going to be evicted. Do you understand that, Mr. Summers?
Sure.
Ms. Summers?
Yes.
Do you agree that Mr. Sobe has your permission to sign your name to this proposed consent judgment?
Yes.
Well, Mr. Summers?
Yes.
Ms. Summers?
Yes.
Since you're unrepresented by a lawyer, you have 3 business days to come in here and fill out a motion to set aside this proposed consent judgment, and you also have 10 days to appeal. Do you understand that?
Yeah.
All right, so you understand you have to vacate, right?
Yeah.
Okay. Ms. Tucker Beck, and you're satisfied with this agreement?
Yes, Your Honor, as long as they comply with the date.
You have to
and-
get out by then, otherwise you're gonna be evicted, folks. So you better go back and start packing. Okay?
Okay, thank you.
Wish you well. Thank you, Mr. Soap. Thank you, Ms. Tucker Beck. Have
Thank
a
you, Your
good
Honor. Have a
day,
great day.
everybody. All
Thank
right.
you,
we're-
Your Honor.
Holmes case. What? Oh, I'm sorry.
Now, this is a powerful judicial moment. The foreclosure buyer tried to accelerate the redemption period, arguing code violations, specifically missing exterior stairs, justified early possession. But the judge pushes back hard. Why? Because redemption rights are statutory protections. After a foreclosure sale, October 16th in this case, the homeowner typically gets a fixed redemption window, here likely 6 months until April 16th. That means unless there's serious destruction or waste to the property, courts are reluctant to cut that time short. The judge essentially says this statute wasn't meant for minor code leverage. And then he does something interesting. He advises the homeowner to get the money together and preserve equity. That's not favoritism. That's protecting due process. Losing a property over less than $10,000 when equity exists would be devastating. Do you think the judge was being fair here, or too protective?